Hey everyone. I promise I'm not leaving you to go audition to be Rudolph in the town Christmas play. It's just actually been cold in Florida for 2 days, and my body's like, no, 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 no. This isn't what we're used to. What are you doing here? So I apologize for looking like a hot mess, but we got this. You have probably seen Mr. Phillips on some other channels because he had a massive freak out and triggered poor Judge Webster, who probably has high blood pressure over having to deal with them. There was a lot of talk back and forth over who was at fault, and I wanted to pull all the information together, not just the little bits and pieces. Let's look at the whole story, because that's how we do things here. So, what initially brought Mr. Phillips to court this time was a charge of driving 86 miles an hour in a 65 mile an hour zone. When he was pulled over, it was determined that he did not have a driver's license that was valid. It was suspended or canceled at the time, and it had been since August 15th of 2023. So this is actually Mr. Phillips' second or subsequent conviction. They only count up to 2. Once it's after that, it's second or subsequent. Like, it just keeps counting. You could have 20 or you could have 3 and it goes in the same, which I don't really understand that, but I get it. He is an absolute peach to deal with, which I will tell you about in just a few minutes, but let's go to court.
Everybody, if you can hear me, this is a court of law, so you need to remove your hats. No smoking, no drinking, no eating. Anthony, if you go ahead and remove your hat for me. Thank you, sir. Also, you guys should see a little microphone on there. You need to mute yourself till the judge calls you into court.
Say.
In addition to what the deputy told you, make sure you have a pen or pencil in front of you. Every time you come to court, bring a pencil and paper because you will guaranteed have something to write down. Also, make sure you're not in a moving automobile. Even if you're the passenger, you need to make sure the car is pulled over in a safe spot. And again, as the deputy said, you are in a court of law. Behave as if you would. Mr. James, you'll need to take your cap off, and you just did. Thank you.
That seemed pretty clear and straight to the point to me. The Sally Port boys explain it well. This is how you act when you have to adult for a few minutes. Life's tough.
.com. Now, William Phillips, did the officer tell you not to smoke?
It's kind of hard to hear around here. I'm out of town on a construction site, and I'm the lead. So,
Well, sir, you're supposed to be in court.
okay, I'm sorry, ma'am.
So you better make sure you can hear. We're gonna have a real problem if I call your name and you can't hear. We're gonna have a real problem if you break rules and procedures. So, in any event,
I like Judge Webster. I think she's really fair. I think she's usually on point. But I also think you can tell by the tone of her voice she is not in the mood today, which I totally get. I'm not in the mood today. I'm all stuffy and my head hurts. And look, I got to have my gloves on because my hands are swelling. And I just want to go back to bed. But some of us have to push through because if we don't get up and work, we don't get a paycheck. So you can see Mr. Phillips, hanging out in all his high-vis glory. he was eating and drinking so far, or maybe that's dip he's got in his mouth. I'm not really sure. But I kept everything in so you could see everything that was going on. I didn't want to delete anything. I did put it on the highest speed I could put it at without it like exploding the video. It's like on 40 speed. It was a long time he was sitting there waiting, but you could see what she was seeing. And there's a whole lot of twisting around and everything else. And I think we are all guilty of getting a little irritated when we're watching a screen and somebody's walking around with a camera, or we're looking at a ceiling fan, or we're looking at the sky, and it keeps going all around because it makes you dizzy. It distracts you from what you're doing.
One quick announcement, Judge. I see people on there smoking and eating and drinking. We need to quit that. You're in a court of law.
Yes, you've all been warned. Not, I saw that too with Mr. Phillips. I saw him eating, I saw him drinking. I'm not as concerned about drinking because I do know our throats, if we do a lot of talking, do get dry. But come on, people, you're in court, listen to your instructions and follow them. And the smoking, stop that.
Thank you.
You're welcome.
That's all we have in person, Judge.
All right, where's that gentleman, Mr. Phillips? What happened to you? All right, let's get you back to work. We are on the record in 2024 TR 1376, State of Kansas versus William Wayne Phillips, with Jared Regier for the state. Mr. Phillips, in count one, you're accused of speeding 86 in a 65-mile-per-hour zone. That is a traffic infraction, no jail time, but a fine. And then count two, driving while your license was canceled, suspended, or revoked. That is a B misdemeanor normally, but the county attorney on August 1st of 2024 filed an amended information alleging that not only were you driving while suspended on May 21st of 24, but that you did have a prior driving while suspended conviction from August 23 in Wichita Municipal Court. That prior elevates this from a B to an A non-person misdemeanor. It increases the fine from $1,000 to $2,500 maximum, and it requires a minimum must serve 5 days in jail up to 1 year in jail. With that minimum mandatory jail time, are you going to be hiring an attorney, sir?
With that, my license has been suspended due to being out of state, and it's no longer suspended out there. Like, I've been going back and forth with California for 3 years over this, and it's no longer suspended. And all I have to do is go get my license here, what I've been told from.
All right, well, they go by what the status was when you were driving. And I think if you had an attorney, he'd probably say, stop talking and wait to talk to him before you make any more statements. But you can waive your right to an attorney and represent yourself. You've heard me tell people all morning that you can hire an attorney if you cannot afford an attorney. You can apply and see if you qualify for court appointed. But now you told me you were the supervisor of a company there, so I'm not sure that you'd qualify, but you can always apply. You could waive your right though and represent yourself, and we can either set this for trial or give you some time to talk to an attorney. What would you like to do?
In the beginning, you said something about obtaining a license, though, because this is just
Oh,
the
you're
first.
thinking about, okay, you're thinking about when I was talking to the group probably about diversion. If you get your license, you can maybe qualify for diversion. I'm not sure you'd be successful. You can always check, but it looks like with your speed, you're probably outside their guidelines. I think I saw something to suggest that. Maybe not. Yeah, I think you're outside the speeding guidelines, and I don't think they divert on second time driving while suspended. But again, I'm not the one that decides that. It's not even my program. It's strictly up to the county attorney. You can always look and see if you'd qualify, but from my years in this business, I have a hunch you're not eligible.
Well, if I need an attorney, I'm not going to get one from you guys. That's most definitely.
All right. Well,
You
our
know what I mean?
taxpayers will appreciate that. Okay, so you're gonna hire an attorney?
Yes, ma'am.
All right, I'll make a note that you're hiring an attorney. And let's put this on a Monday.
Yes, Judge, that'll be October 28th.
Can it be scheduled after that? I won't be back into this area for the next like 2 or 3 months. So
Now, I'm not gonna put it off 2 or 3 months, but I can move it up. Do you want to try to do it before you leave? When are you leaving?
I'm already gone. That's
Oh,
the
you're
thing.
already gone?
Yeah. So I mean,
Where are you, in California?
no, I'm in Independence, Kansas.
Well, that's not that far.
It is when I have to work. I mean, the only reason why I've been driving back and forth with no license is because I have to feed a family. You know what I mean? So
I understand what you mean.
and that's not an excuse. That's a reason. So
All right, give me that date again.
Farther out than October
No,
28th,
I
Judge?
don't want to do
Okay.
that. Now, how long are you going to be in Kansas, though?
how long am I going to be in Kansas?
Right, are you leaving state for any reason with your work?
No, I won't be back around El Dorado for like 3 months.
Okay. All right, sir, I'm detecting a bit of an attitude, and I've had a bit of problem with you all day long. I'd suggest you kind of take a deep breath and try to get rid of the attitude, because then if you don't, you may cause me to have to get an attitude too. So,
Well, likewise, take that deep breath. Do the same thing. You know what I mean?
excuse me?
I said same. Do the same thing. Take that deep breath.
Like, are you serious right now? You don't disrespect people who are in a position above you in a circumstance. Your teacher, your boss, your judge, when you have broken the law and are going to have to suffer some kind of consequences from it. Like, don't piss that person off, because they're going to have to do something to you, and you want it to be as little as possible. It's like when your parents smack you on the butt and you're little and you say, "Oh, that didn't hurt." And dad whips off the belt. Yeah, that only happened once. So, WTF? I just want to say, like, it blows my mind, like, that people have such disrespect. In my mind, that is entitlement at its absolute fullest, because he broke the law, he got in trouble, he had to go to court for it. He didn't do what he needed to do to get a hardship license or whatever, so he just kept driving without a license. Okay? In addition to that, he was speeding 20 miles an hour over the speed limit. He's sitting in a vehicle driving right now while on camera. And he is pissed off because she won't push the court date out more than 3 months so that he can keep breaking the law by driving without a license. Like, where do you justify that in your mind? I want $1 million, so I'm just gonna stomp my feet and pitch a fit and hold my hand out until someone gives it to me? Like, I don't understand. I can't process this. I can't. I'm sorry. Okay, on with the show.
Yes, Goose Fraba.
All right, Mr. Phillips, do you know what my title is?
I do, but that doesn't give you the right to belittle me or anybody else in your court. You know,
All
you
right,
have a code of conduct and
okay,
ethics you have to follow.
I am finding your conduct contemptuous because you're interfering and disrespecting the process and the court. You are hereby fined for direct contempt of court, $100 cash payable in 1 week to the clerk of the district court.
That's fine.
And if I have any more problem with you, it's going to go up a little bit more. And if I have any more problem with you, you can go to jail over it. You don't seem to be respecting or appreciating this court. You've drunk. I can't remember if I saw you smoking. You've eaten since this hearing started. You've rolled your eyes. You have just been totally inappropriate. You've complained that you can't be here when I tell you to, that it's inconvenient because you're maybe a couple hours away. Some of these people are in other states. I had someone from Australia on the docket here recently. So don't tell me.
But that's not this case. That's not this case. This is my case, not their case.
Yes, it is. And that's
No, it's
$200 for contempt. You better get a clue who's in charge here and why you're here. It's because you were allegedly violating the law. I didn't go out and find you, and you are not to respect to any court or disrespect to any court that way. $200, Mr. Phillips, due in court Monday, or you can serve 3 days in jail if it's not paid by 1 week from today.
1 week from today.
This is my final order on the subject. $200 to the clerk of the district court 1 week from today. And if it's not paid,
So is it Monday or is it 1 week from today, which would be Wednesday? Because you're going off of business days, correct? Shouldn't my screen?
you're ordered to be in court, in the courthouse. August 21st, 2024, 9 a.m. You are to be in El Dorado, Kansas, at 201 West Pine, the Butler County Judicial Center, August 21st, 2024 at 9 a.m.
So you're making me appear under duress and coercion and threats of incarceration, pretty much. I'm just trying to understand this because before you were willing to do it, and then you said I had a disrespectful attitude, but I've been listening to you, ma'am, all day, just drilling everybody. You know, I'm a supervisor on a construction crew, and I don't even drill my guys like that or their family members. I know this is being recorded, so I would like a copy of this because I'm going to take this to an attorney.
You are to be here in person at the Butler County Judicial Center, 201 West Pine, El Dorado, Kansas, 9 a.m., August 21, 2024. I have found you in direct contempt of court for your attitude, your comments, your disrespect, your delay of the proceedings because I'm having to take extra time away from others to deal with this arrogance and the eating and the drinking and so forth. And you owe the court
I don't owe you nothing. I owe the court and the state of Kansas. See, that's your problem. You're taking your own personality into your law, and that's not appropriate. That is not appropriate. You were talking to some lady about her mother forgetting and then grilled her about her forgetting. That's not her mother's position.
$500 cash.
Can we hurry up and get this over with?
$500 cash for direct court.
That's fine.
$500 cash for direct court. And I am ordering you to surrender yourself by 2:30 today to the Butler County District Court. 2:30 today.
I cannot do that.
Well, then you're making me send a sheriff out to get you.
Because you're putting your personality in this, man. I'm going to hire an attorney. I am going to get off this Zoom, and I want this sent to my email. I know your deputy is listening, and I demand this footage because I'm going to take this and I'm going to appeal all of this. You have been
500
delaying the court the whole time.
All
nagging
right,
and
I've
telling
given you
other
my
people,
order. Disconnect him from the call. He better be here. The sheriff will go
I
after.
will not be there.
All right, the
That
sheriff
is
will
under
come get you.
threat of
What
that
is
is
your
under
address?
collusion
Where are you
and threat
located?
of imprisonment.
Mr. Phillips, where are you located?
Not here.
You refuse to tell me your address and your location?
That is under threat and incarceration. I want my attorney present.
What company do you work for?
It is none of your business. You will be informed through my attorney. My attorney, yes. I need you to state your name for me.
So you refuse to tell me where you're located. You refuse to tell me
That is
your
under threat,
address.
ma'am. That is under threat over a speeding ticket when you kept arguing with other people. I've been on this call patiently waiting at work. Patiently waiting. When I called because I got a reminder this
Disconnect him
morning
from the
out of
call. I'm not
town,
going to
and I
allow
was
him to
trying to
disrupt these
reschedule this.
proceedings anymore. Missy,
I
disconnect
was
him.
trying to reschedule it, so
All right, folks, let's move on.
Do you think he actually showed up at the jail that day? However, there was an order issued. Order in sentencing, finding defendant in contempt of court in order to take into custody. Now on this August 14th, 2024, in open hearing, the court finds the defendant in direct contempt based on his disruptions, disrespect, and violations of court-ordered, I think that says court orders. It's a bad copy. Pursuant to KSA 20-1203, the basis of contempt include the defendant smoking, eating, drinking, and getting in and out of his truck, putting his hat on and off, and walking all about during other defendants' cases throughout the docket call and in direct violation of prior court orders as given by the court itself as well as its designee, Sallyport Boys, a special court security officer, a specific court security officer. These behaviors are not only in violation of direct court orders, but are blatantly disrespectful and disruptive. Audio and video of such behaviors exist and are available. Yes, they are. I can give it to you if you want. The court also finds the defendant's subsequent comments once, God, I can't read, I can't talk, can't think. Once his case is called to be highly disrespectful and disruptive. I will second that. Oh, it wasn't a motion. Sorry. The defendant continues to talk over the court and not only to make rude, personal, insulting, and disrespectful comments about and to the court, but blatantly refuses to answer the court's inquiry about such matters as his address, his employment, and his current whereabouts. He further tells the court he is not going to follow its orders to report to court in person later this date. In fact, he does not appear at 2:30 p.m. as ordered, having found the defendant in direct contempt of court multiple times and having attempted to diffuse repeatedly the defendant's outrageous conduct, which unduly prolonged the other defendants' hearings. The court first fined the defendant $100, then increased it to $200, and finally orders of a total of $500 due to the court, as personally told the defendant in open court. Said fine still does not dissuade the defendant from his ongoing contemptuous conduct, so the court orders him removed from the call by the Zoom administrator, and said order is fulfilled. The court orders any law enforcement officer who may find the defendant, whether he may be, wherever he may be. I have a really crappy copy. Like, how do you get crappy copies anymore? Like, we don't have fax machines. Everything should be crisp and clean. People don't change their ink. That's what it is. Trying to stretch that ink cartridge. Ink's expensive. Court orders any law enforcement officer who may find the defendant, wherever he may be, to apprehend and detain him until he can be brought before the court for further sentencing on his subsequent direct contempt, failing to appear at 2:30 p.m. this date. So ordered. It is ordered. Oh, I need a gavel. Phyllis K. Webster, District Magistrate Judge with awesome glasses. I have an eye doctor appointment like in an hour. Oh, I'm not going to make it. I should get Judge Webster glasses. So on September 11th, he was taken into custody on, I am not sure if he turned himself in to the Butler County Jail or if he was apprehended, but he is back about a month later, September 11th, and this time he gets Judge Ricky. Here we go.
All right. William Wayne Phillips.
Yes, sir.
All right,
I would just like to apologize for my actions. The reason why I'm here, I was having a really bad day, and I let my mouth get the better of me, sir.
Okay, we'll address that a little bit more in a moment. This is State of Kansas versus William Wayne Phillips. It's case number 2024 TR 1376. Mr. Phillips appears from the jail Zoom location, Devin Canfield, as prosecuting attorney. I do see in this file an order and sentencing finding defendant in contempt of court and order to take into custody due to disruptive behavior, apparently on August the 14th before Judge Webster. Review the court's order. You were found in direct contempt of court multiple times, Mr. Phillips, and I appreciate your apology for having a bad day, but orders have already been made. Court first fines the defendant $100, then increases to $200, and then finally $500. Said fine still does not dissuade the defendant from his ongoing contemptuous conduct, so the court orders him removed from the call by the Zoom administrator, and the order was fulfilled. Court orders any law enforcement officer who may find the defendant wherever he may be to apprehend and detain him till he can be brought before the court for further sentencing on his subsequent direct contempt of court, failing to appear at 2:30 p.m. this date as ordered. Well, that was a really bad day, Mr. Phillips.
Yes, sir. I work out of town, and I suffer from bipolar syndrome, and I left my medication at home, and it was just one thing after another that day, and I let my mouth overrun my intelligence, and I tried to make it here on time, but I was working out in Independence, and when I came here, I felt that if I would have turned myself in, it would have been more bad than it was good. And then I just made a snowball get bigger, sir.
Hmm. So eventually you were just picked up on an arrest warrant.
Yes, sir. I was picked up on Thursday.
On Thursday?
Yes, sir.
Okay. And where were you picked up at?
In Wichita, in Mays. I was leaving the company I work for, their yard out in Goddard, to another location, another job site. And then that's how I got picked up, sir.
Okay, so when did you arrive in the jail in Butler County?
Monday is the soonest they came and got me, sir.
Okay, well, apparently you didn't see a judge on Monday then?
No, sir.
All right.
And
Anything about that statement that you would contest regarding how long he's been in jail, Mr. Canfield?
Your Honor, I was looking through the booking sheet now. I've not been able to find exactly when the defendant was booked into our jail, but I have no reason to believe that that's incorrect.
And I could pay the $500 upon my release today or whenever.
All right.
I just want to keep my job. I'm the only one that works in my household, and you hear this all the time that the longer I'm here, the more jeopardizing that it goes to my family, and that's the only. I understand I did wrong and I need to be, reprimanded for that, for my actions. And like I said before, I truly apologize. There's no excuse for it, sir.
What about these underlying charges, Mr. Phillips? I know we've talked about the contempt, but not while we haven't talked about why you were in court in the first place. You had a speeding charge, 86 and a 65.
Yes, sir.
And you also had a driving while suspended, a Class A misdemeanor. Apparently, it's not your first.
No, sir. I've been working with the state of California to beginning of August. I had paid all my dues to the California to release my license, which they returned to me because my license has been suspended for 23 years for no reason. Pretty much, yeah. And I finally got it resolved, and I've been in constant step on trying to better my situation with my driving and then also with my license, trying to be productive in every way that I can within, society, if you would. And it was just,
Are you wanting to try to get your license reinstated before trying to resolve these charges? Is that your goal?
that's my goal. I'm
Do you intend to do this on your own, or do you want the court to consider a court-appointed attorney?
wait a second. Did you say I tried to get my license on my own or an attorney?
Well, handle this case. Are you going to, it doesn't appear that you've had an attorney appointed in the past, and I don't even know if you qualify for one.
No, sir. I planned on getting counsel through Charlie O'Hare's office.
Okay.
O'Hare in Wichita.
Okay, well, I encourage you to go ahead and do that. I'm going to go ahead and establish a date then on a future calendar. How long is it going to take you to get this attorney hired and get this business taken care of, Mr. Phillips?
So Thursday when I got picked up, we had just moved from our old house. We were moving this weekend. So a lot of that has been tied up in that. But the sooner I can get back to work, the sooner I can set everything into motion. Like I already have a couple of $100 saved up for the attorney. And then I'm trying to figure out how to go about, because in California, you have to call a number, which is their driver's license helpline. And I'm not sure how to do it here. I don't know if I have to take off work to go to the DMV, or if there's a number, or if there's online service I can do. I don't know how to go about it.
Okay. Well, here's the thing, Mr. Phillips, the court date I have for Judge Webster, who's pretty upset with you right now, is not until December, but I think I really want to keep track of this case and set a court date much, much sooner. So I'm going to set you on an expedited docket with a different judge, Judge Lee. You can explain your situation to Judge Lee at that time. He can do appropriate future scheduling if necessary. But I'm going to set you on a docket 1:30 p.m. on September the 20th. That is a Zoom docket, Mr. Phillips. Now, you've handled yourself very appropriately today, Mr. Phillips, and I appreciate that. But when you get on with Judge Lee by Zoom, because this is a Zoom docket, so you can participate from the road, but you need to have good audio, good video, and participate fully September 20th at 1:30 in Judge Lee's court. Okay?
Yes, Your Honor.
I don't think we have
Thank
are there some standard Zoom numbers for that docket, Mandy? Because he's not represented, so I don't know how he's going to get the Zoom invitation.
I think I have to call, because when I did it before, I was calling to actually reschedule my court date. And when I called up here, she automatically gave me the number and the password. So,
well, as long as you're on this meeting with no excuses, Mr. Phillips, September 20th, 1:30, Judge Lee's court. Okay? you need to appear by audio and visual means and readdress your case, and then explain the situation to Judge Lee, and then he can do appropriate future scheduling if necessary. And in the meantime, if you can get the O'Hara firm on board, you need to give them that court date.
Yes, sir.
So September 20th at 1:30. All right, Mr. Phillips. I do note in the docket notes in this case from August the 14th, that Judge Webster ordered the $500 fine to be paid to the court in 1 week or 3 days jail time served. Well, if your information to the court is correct, you've already done twice that. Sounds like you've done about 6 days so far.
Correct, Your
Is that
Honor.
right?
Yes, sir.
And you've certainly been in jail since Monday. I'm going to go ahead and order you released at this time on the contempt sanction.
Thank you, Your
I'm
Honor.
going to direct that you pay the $500 fine that you've already told the court you could do. So get that paid within 1 week from today. Better yet, right away.
Yes, sir.
And get that part of your contempt order discharged. Sounds like from the wording of the order of sentencing on this contempt that you earned every bit of that fine.
I did, Your Honor. Every single bit of it and jail time.
Rude, personal, insulting, and disrespectful comments. Just no place for that in the system, Mr. Phillips. But you've done so much better today, I'm willing to give you another chance.
I appreciate you, Your
And I
Honor.
would hope that if you ever appear again in front of Judge Webster, that you start off with the same sincere apology that you started off with this court today.
That's what I planned on doing, Your Honor.
All right, Mr. Phillips. Now, if you have other holds on you, I'm not releasing you from those. But when it comes to the contempt hold or any hold in this particular traffic matter, I'm going to go ahead and order you released. Let me see if you had a bond.
It said no bond.
Well, now I'm going to place you on an OR bond.
Okay.
Your Honor, if I may,
Yes,
I did speak with the clerk's office just before this hearing, as I did not see any notes about a bond set at the last hearing. The clerk's office let me know that a bond of $500 cash was set, but as the court is issuing an OR bond today, I'd ask for a 1,000 OR bond.
that's. Court will adopt that recommendation. Court will allow Mr. Phillips to sign out on his own recognizance, $1,000 amount, which means if you don't show up next time or in the future, Mr. Phillips, you're going to owe an additional $1,000 on top of everything else. But the bond is established in the case at $1,000 OR with the next court date, September 20th, 1:30 p.m. by Zoom with Judge Lee. Okay.
I have a question, Your Honor.
What is it?
So I'm getting released and then I have to pay 1,000?
No, well, you can if you want to, but really you're signing out on your own recognizance, on your own promise.
Okay.
So you're not having to put up money today, but you still have to pay the $500 fine.
Yes, sir.
Okay.
Yes.
I think we're on the same page. You need to get
Okay.
that done within the next 7 days.
Yes, sir. Will
If
do.
you don't have any other holds, you should be able to be released today, Mr. Phillips.
Right, thank you, Your Honor.
All right.
And again, I apologize.
Apology accepted by this court anyway.
Thank you, sir.
We'll move on to another matter, Mr. Phillips. Have a good afternoon.
Likewise, sir.
Versus William Wayne Phillips, case number 24 TR 1376.
Your Honor, while you're doing that, may I have that breakout room?
Yes, you may. I'll
Thank
approve that.
Which
There's,
one? Which one is Mr. Houchin?
right.
Okay,
Sallyport 2 is where they want him.
Okay. Let the record reflect that Mr. Regier and the defendant, sir, are you William Phillips?
Yes, sir.
All right. Mr. Phillips, do you have an attorney?
I do not, Your Honor.
What is your intention concerning an attorney?
If I needed to, I was going to obtain counsel. independently.
All right, now I'm going to go through here, your first, or your appearance on our August 14th. And you were ordered to do some things after being found in contempt. Then it looks like on September the 11th, you were before Judge Rickey, and you indicated you would be retaining your own counsel, and this says O'Hara.
Yes, sir.
And bond was set at 1,000 OR, which you're apparently released on, and you were ordered that you must pay the $500 to the court for the contempt within 1 week. Has that been paid?
No, sir. I haven't been paid since I was incarcerated for that 7 days. I was not issued payment. So this Tuesday, when I get paid, I was going to talk with you if I can get a little bit of extension. Until then, that's my payday.
All right. Well, Mr. Phillips, how are you wanting to proceed with this case? Are you requesting a trial? Are you requesting, what is you wanting to do?
Well, I'm also in legal steps in Sedgwick County. I also have the same type of case there, and I'm working with the state's prosecutor there to obtain my license due to the fact that California had suspended it for 23 years unconstitutionally, and they had wound up suspending that and then lifting it earlier this month, or middle of August, actually.
All right. Mr. Phillips, I asked you how you want to proceed with the case. Is that, are you requesting a trial? Are you wanting to enter a plea? What are you wanting to do?
I'm requesting that the court grant me an extension to obtain my license with conjunction with Sedgwick County and the state prosecution there, who is willing to.
All right. This court isn't a part of any negotiations with the Butler County attorneys, certainly, or Sedgwick County. You've had over a month in regards to, since you've been in court on this case. You've indicated you're going to have an attorney. Now you're indicating you're not, and you're asking for this to be continued. And I'm not going to do that. I'm going to set this for trial. And if you are going to be represented by counsel, then you need to hire them. We'll set this on. Jen, hold on. Jen,
Yes,
let's set this on the trial docket.
You want the
That's Judge
trial,
Webster,
the bench trial?
bench trial.
Give me 1 second, please.
We'll also need a date on Judge Webster's docket. I'm going to order that he appear before her to answer on the contempt citation. She was the judge that issued it. He hasn't complied with it, it appears. If she wishes, I want her to address that, whether or not she's going to, how she's going to deal with the violation of the contempt. So we'll need a hearing date on that as well, on Judge Webster.
Okay, I have a Judge Webster bench trial on November 13th.
Okay. So Mr. Phillips, your date for trial is November the 13th at, is that the 9 o'clock docket or the 1:30 docket?
That is the 1:30.
All right, at 1:30. You are, and we'll do you have another date for him to answer on that contempt?
I've got a misdemeanor control on December 9th.
I was looking for something earlier than that November date, if you have it. If you don't, then we'll just set it for the November 13th at 1:30.
Give me 1 second,
And if
please.
you don't, that's fine.
The bench trial November date is the earliest I have,
Very
and
well.
as far as anything else before Judge Webster, it is all the way out through December.
All right. Mr. Phillips, your trial date is November the 13th at 1:30. I'm ordering that you be at the courthouse at court security. That it'll be a Zoom hearing, but like others that you've seen, been here through, you'll be at courthouse security to do that, conduct that trial. You have the right to an attorney, as was explained in the first appearances. If you wish to be represented by counsel but cannot afford one, you can apply to the court for court-appointed counsel. However, if you wait until closer to the time for trial, that's probably not going to be allowed. You've had time to I don't know what your income is, if you would qualify or not, but you do have the right to be represented by counsel. You need to be prepared to go one way or the other on November the 13th at 1:30. I'm going to continue your bond, but you are to be at the courthouse for that, and you'll need to, it'll also be on Judge Webster to determine what, if any, how she wishes to proceed with the contempt sanctions that were imposed. I would strongly recommend you get that paid in advance, well in advance. But
Yes, Your Honor.
that's a recommendation.
I have one more thing, Your Honor, if I could. Is there any way that the state would be willing to do probation on this matter?
You need to contact them, not that in the courtroom is not when the negotiations take place. If you're represented by counsel, then they need to do it. If you're waiving your right to an attorney, you'll need to unequivocally let them know and that you're going to represent yourself so that they can speak with you. But if you're going to have an attorney, you need to do that. But if you're going to contact them, that's outside of court time.
Yes, Your Honor.
Very well. Mr. Regier, anything further?
Not in this matter, Judge.
All right. Thank you. This matter is adjourned. Mr. Phillips, you're free to go.
So the court date is November 13th at 1:30
Correct.
for this? And then you said there was another one that was set at another time?
No, they're both, but your contempt citation, how the Judge Webster wants to deal with that. If you haven't complied with her orders, that's up to her at that time. And your trial is also set at that time.
Yes, sir, Your Honor.
Very well. All right.
Thank you.
That matter is adjourned.
Do that wherever you need to.
There you go. Okay. All right, we are on the record in 2024 TR 1376, State of Kansas versus William Wayne Phillips. Please announce appearances.
Jared McGee on behalf of the state.
And please court, Mr. Williams appears in person with counsel Kevin Zolator.
Hang on.
This matter is set for bench trial today. And Mr. Regier, I see, has subpoenaed Trooper Andrew Lieber, who has been with us since 1:30. Now then, Mr. Zolator, does your client still wish to exercise his right to a trial?
No, Your Honor, we're requesting a continuance.
And for what reason?
We were just recently retained, I think, a few weeks ago.
Well, this case originated with some kind of traffic stop, May 21st of 2024. The defendant had first appearance August 14th of 24. He appeared before Judge Rickey in custody September 11th, 24. He appeared before Judge Lee September 20th, 2024. Each time, this time he requested a continuance and the Chief Judge Rickey denied it. No, I'm sorry. Judge Lee denied it and set it for bench trial today before me. That was September 20th, the trial was set. The defendant told me back on August 14th he was hiring an attorney, which he has. And I show an entry of appearance filed October 24th. We're set for trial on charges of speeding 86 and a 65. We are also set for trial. Let me look at the amended complaint filed August 1st, see if there's anything still remaining. Count 2, driving while suspended after a prior conviction, a Class A misdemeanor. Mr. Regier, your response?
Your Honor, for the sole purpose of it, well, Your Honor, forgive me, Your Honor. I will, if I may, respectfully request 30 seconds.
Granted.
Thank you, Your Honor.
What?
Let's say idle, we're not muted.
No.
Not muted. Behave yourself, deputy, whatever you're doing.
I was just gonna say hi to my former supervisor.
Oh, is that Trooper Lieber?
Yep.
Okay, I'll let you do that.
I sent you a text earlier, Johnny.
All right.
Thank you for the court's indulgence, Your Honor.
You're welcome. While you were away, I found out that Deputy Throckmorton, who spent many years with KHP, was supervised by your witness today, Trooper Lieber.
Very good, Your Honor.
All right. Now, your response to the request for continuance, Mr. Regier.
Your Honor, for the sole purpose, if indeed the continuance is being requested, other than recently retained, perhaps there are some other reasons which I'm sure counsel can defer to the court better than I can. I would advise the court, in accordance with my duty of candor as an officer of the court, that I am not aware if discovery has been provided in this case. Certainly, legally, that is something counsel for the defense would be entitled to. However, to refresh the court's recollection.
You don't have to refresh my recollection, counsel. He entered his appearance October 24th, 2024. You can't tell me if you sent him discovery?
Your Honor, for my understanding is that issue is still outstanding, so.
I don't want it outstanding. I want you to check your file and tell me if he's had discovery and when he got it.
Your Honor.
Or, Mr. Zolator, you're an officer of the court. Do you have discovery and when did you get it?
Your Honor, I do not have discovery in my file with me, but I am not going to advise the court that I've not received it without checking the office file, which I can pull up now.
If you would, please.
I am doing that now.
Meanwhile, Mr. Regier, if you have an answer from your end, I'd appreciate that.
And while I look, Judge, I think Mr. Regier was referencing other reasons. Obviously, we were just recently retained. I haven't had an ability to discuss with Mr. Regier possible resolution short of a trial. But, you know, all that I thought was somewhat implied in my statement that we were just recently retained. I don't think we've had sufficient time to do all the things normally that are done before a trial. But I am pulling it up now and I can tell you if we've received discovery or not. It does not look like on my end, Your Honor, we have received discovery.
Mr. Regier, how long does it take your office to get discovery? I mean, October 24th, he requested it and it's now November, what, 13th? How much longer do you think you'll need to get that to him by computer?
Your Honor, under these circumstances, the state does not object to this matter being set over.
Well, my question was, and I don't know if Mr. Zolator is the office attorney, I don't think he is. But we've had this issue before, and I have repeatedly ordered discovery go to the attorney. And what was it, 128 day? No. I can't remember the number of days that your office, even though I had ordered him multiple times to receive that, had still not sent him full discovery. I hope we're not going to get caught in another one of those situations where I order it and it's not done. And I'm concerned that now I'm hearing that after all this time, he hadn't even had it sent to him. So do you have any assurance, better than what we've had in that other case, that you'll send it to him, Mr. Regier?
One moment, Your Honor.
All right. I frankly don't recall who the attorney was that we were having that problem.
Yeah, and from my end, Your Honor, and I've never had problems with Mr. Rieger getting me discovery. My request was not based on, and I understand the court's frustration. I'm not trying to play both sides. We haven't had it. I wasn't complaining about that at this time. Frankly, I don't think a trial is going to be necessary if I get discovery and I'm able to talk to Mr. Regier, be more efficient that way. So that's my request. And I don't have any prior, I don't know what case you're referring to, but I would expect that I would get it in a short amount of time.
Well, Mr. Regier, do you recall which case I'm talking about?
Your Honor, not by number, although based off my records, it would appear that my office has communicated with Mr. Zolotor's office as recently as within the last 24 hours on the outstanding discovery issue. I would anticipate that being resolved in a timely fashion.
So we've had this bench trial set all this time, and they finally had a communication with him about discovery the evening before. Yes, I am frustrated. This is not the way cases are handled or to be handled. Particularly in this case, where the defendant has been told by multiple judges that we would have a trial. Judge Rickey said he said it. Let me get my judge. Judge Rickey told him he was setting it for jury trial with me, and now I strike that. Judge Lee told him it was going to be set for jury trial. This has just been, he's seen 3 judges over the course of a number of months. He's told each of us he was going to hire his attorney. And now we come in here after he was specifically told to be ready to go to trial today, and he's not. And the reason you all know, I'm sure, that I am expressing frustration with this defendant is because he cannot do what courts tell him to do, according to my experience with him. And let's put that camera over there a little bit further so he can participate in these hearings. This defendant has told me in no uncertain ways that he doesn't have to give me what I ask for. He won't do it. He does not have to appear when I tell him to, and he has told me he won't appear when I tell him to. He has called me names, referred to me in a negative light, and he just does not seem to appreciate the judicial authority of me, of Chief Judge Rickey, or Judge Lee. He does not do anything any of us tell him to do, except I am impressed he shows up today with an attorney, one of which I know is very respectable and does do what he says he's going to do. So we are making progress.
To that end, Your Honor, at some point, my client would like to address you.
The other issue?
No, to address you.
All right. Well, at this time, I will grant the continuance at the defendant's request, but it's going to be the only trial continuance because I feel like this defendant has just been trampling over the judicial system for months now, just literally trampling over it. And I don't know, Mr. Zolotor, if you've seen the videos from earlier hearings, but if you haven't, you really need to.
We have.
All right. This case will be continued. When's our next bench trial? Or does he want a jury trial? I have a jury trial in February.
Your Honor, I haven't discussed that with him. I am representing to the court that I do not think a trial will be necessary. If I must elect, I will have to go with a jury trial at this time. because I have not talked to him about waiving his constitutional right, which I think is guaranteed because it's a Class A misdemeanor, not a Class B. If
Very
we set
well.
this for a status, I think we can probably get this resolved. I can't guarantee that. If you don't want to do that, I would request the jury trial setting in February.
I will set it for jury trial, but you'll need, of course, make the written demand and so forth. Because I just don't want to let him, of course, like I said, he's got you now and you're not prone to play the games that he has. So, all right. When's our next available status conference? Not until January?
Let me check, Your Honor.
Okay.
How much time do you want to give them? I do have a couple slots left, literally 2 on December 9th.
December 9th, is that enough time for council to prepare?
If not, I could do one on December 30th, and then we're into next year.
What time on the 9th?
9 a.m. It will be
Uh,
from the,
Whoa, we're not doing, a status conference. Yes, we can do a status conference at 9 on the 9th.
I would not be available on the 9th. On that other
Okay.
day, I might be available. What was the other day?
December 30th.
And I apologize, Your Honor. I'm not available that date either.
Okay.
Okay, let me,
But
Well,
if we
let's
can
just set it-
resolve this, I certainly will try to get a plea date before then.
Okay, well, let's set it for pretrial February 3rd, 2025 at 9 a.m. and that will be by Zoom. The pretrial will be by Zoom. But of course, the bench trial or the jury trial that I'm setting will be February 5th and 6th, and that will be live at the courthouse. And the defendant, as condition of bond, is ordered to appear both dates and time. He needs to appear at the courthouse. I cannot trust him not to appear at the courthouse. So make sure he's here at least at the courthouse. Then if you want to be with him in person, that's fine too. Okay, so continued on your bond with those conditions. Anything else before we get to the other point at hand?
No,
No.
that's fine, Your Honor.
All right, now the defendant was found in contempt multiple times and still wouldn't quit disrespecting and disobeying the court until eventually he was ordered to reappear later the same day in person at 2:30 p.m. He told me he wasn't going to. He wouldn't tell me where he lived, where he worked, blatantly refused to answer any questions of his whereabouts or anything I asked of him. He continued to smoke during the Zoom, even though he'd been told not to. He continued to eat and take an enormous amount of drinks. And he continued to get in and out of his truck and walk around the job site, take his hard hat on, take it off, walk all about, all during other defendants' hearings. And then when his case was called, that's when he started becoming blatantly, verbally disrespectful and telling the court how to do its job and not do its job. Throughout the docket, he was highly disrespectful and disruptive. He would talk over the court. He would make rude, personal, insulting, and disrespectful comments about and to the court. And ultimately, he was found in contempt to the point that he'd earned $500 in fines, and he was told to get that paid within a set time that he did not. He was told to appear later that day at 2:30 in person, which he did not. And then he saw Judge Rickey, Chief Judge David Rickey, on September 11th. And Judge Rickey found that he still had not paid the $500. And he gave him 1 week to get it paid. And in fact, he gave him an OR bond, which would have made it easier for him to pay the contempt within 1 week. He didn't pay it. He saw Judge Lee September 20th. Judge Lee said, well, he'll leave the contempt up to me when he sees me again. But he still hasn't paid it. Once again, he has totally disregarded court orders. So let's first deal with the consequences of his not paying, as multiple courts have ordered him to do. Then I want to address his direct contempt of not appearing when he was told to do later that day of August 14th. Now, whether we address Judge Ricky's orders that he violated, that we may postpone and let Judge Ricky decide if he wants to pursue that or if we want to go after him at a later date. But right now, I want to focus on his contempt of court, where he has not paid the $500. That's another act of contempt, and is not appearing as he told me he wasn't going to do and didn't, even though I ordered it. So let's start with why he hasn't paid, followed by why he didn't follow my order to appear. Counsel?
Well, first, Your Honor, I do know that he would like to apologize to you if you'd allow him to do that. And he doesn't have an explanation that's going to justify his conduct, nor is he going to try to. But I know he wants to apologize. I mean, the money's one thing. He doesn't have a lot of money, but his conduct is something he can't control no matter what. And I do, if you allow him the opportunity to address you, I think we'd like to start there if that's okay with Your Honor.
Well, normally I appreciate a kind apology, but frankly, I'm not sure it's going to be sincere, and I don't want it unless it's sincere, Mr. Zolator. I sense if he makes an apology, it's going to be because his attorney told him that he needs to do that.
Well, Your Honor, I would throw it at your feet, let him apologize, and whether you find it sincere or not, I mean, I can't make that judgment for you. I think you know that, but I'm not trying to speak for you. I'm not sure what else I'm supposed to do other than let him. I mean, I will stand away and let him make his remarks.
All right, go ahead, Mr. Phillips.
I would just like to say I am very sorry for my actions that day. Again, me apologizing doesn't give my actions justification in any means or in any grounds. I disrespected you, your court, your officer here, the DA, and I've been under a lot of stress working out of town, very many hours with very little pay, and there's no excuse for it. I just more bad things happening compiling, and it all came out in the very wrong place, wrong time with the wrong person. And I am very sincere in my apologies. Not when all this happened, I wanted to apologize, and even if you go ahead and read the other cases, when the other judge sentenced me when I was in Burlet County, I was even apologizing then. I think I had the same district attorney there where I was trying to apologize, but at least to you, if not to you, to someone that can actually hear the apology without someone sitting next to me trying to say, maybe he had, someone tell him to do it or whatever. I am very sorry. I mean, my actions are out of line and there is no excuse for it. I'm truly sorry for disrespecting you personally and the court as well.
Well, I think the whole day of August 14th started off bad because I have a note that before court even, you had called one of the clerks and informed her you weren't coming to court because you were working in Independence, Kansas. And she explained to you that you could appear by Zoom and gave you the codes. And we weren't sure based on your conversation that you were going to appear, but you did appear by Zoom, and then the rest of it went from there. So why did you not, I'll strike that. You still have not paid the $500, and no matter how sorry you are, your conduct was outrageous, and it's not going to be just excused. You've had since August 14th to pay that. You gave me the impression that you were a powerful employee of a well-to-do company and you were making good money, that you emphasized you were the supervisor. And you showed me by walking around that you did have a crew there. Now you're saying you're underpaid. Are you going to offer the underpayment as justification for not following my order or Chief Judge Ricky's to get that paid?
She's asking you why you haven't paid.
No, Your Honor. when we were in court that day, you said I had to pay it or do 3 days in jail. And that's the whole reason. I mean, if you go back in the Zoom videos,
That was that your understanding?
that was my understanding. That was my sincere understanding. So when I went back in front of that judge, I was asking the same questions, like, do I still have to pay this, or what's going on? Because it was 3 days, I did 6. I just don't understand. And he said, we're gonna let you decide that, because I'm still willing to pay it, but my understanding.
Excuse me, sir, that is what the third judge said. Chief Judge Ricky told you September 11th, you would pay it within 1 week. He didn't give you any jail time, and I don't think I did either, because I told you to be here that day at 2:30, and you didn't show up or pay. So I don't buy that you misunderstood, and that somewhere are you saying you think you paid it because you got arrested and had to serve a little time before the judge saw you?
Well, yeah, I thought it was like.
So you not only misunderstood me, you misunderstood Chief Judge Ricky when he said you pay that 500 within the week.
Just
Is that a yes? Is that a no?
Well, I didn't know if I was waiting to see if I could. Well, yes, because it was the 5, and then he said something about $1,000, and I wasn't even asking then. I'm confused.
And Your Honor, I certainly can help him understand the situation. I can tell the court that he's done 6 days, which wasn't part of the order. It was money, and he's done 6 days, which I think is, a bigger sanction than $500. He's certainly telling me, and I know he's got someone here with him, that they can get that paid, and they will pay it. It was, you can judge this as sincerity, Judge, and it doesn't sound like you're buying it. That's fine. I understand that. But this all resulted from his behavior that day. And I hope at least I did find that sincere, but maybe you don't, of the way his conduct, and he can't excuse that. The money, it sounds like he was confused whether you buy that or not. I don't know. But he did do 6 days on a driving while suspended case. It normally carries a 2-day minimum. And that's, well, yeah, but actual serve time anyways.
All right, we won't get into that. Okay. Well, I think it's clear that I ordered him to pay $500, and it is well past the date he was to pay it. I think it's clear Judge Ricky told him to pay it. It's not what he thinks, it's what the judge says. So is he going to pay that today, counsel?
He does not have $500 today. It doesn't sound like.
I could pay something.
Can you pay anything?
I could pay something.
Well, you're able to pay a pretty prestigious attorney there, and you're able to talk the judge into giving you $1,000 OR bond so that you can pay it, and you still haven't paid it. I question your sincerity if you intend to pay it. I thought somebody was implying you had someone there to help you pay it.
No, I was talking. If you can give me a second, Your Honor.
All right.
Your Honor, I'm being told they can make a $200 payment today.
And the other 30?
And then they can pay that within, if you give them 30 days, they'd have the other 300 paid off.
The time he spent in jail was for failing to appear at a designated court date. It doesn't address necessarily any subsequent contempt. I will allow him to pay the $200 today with the remaining 3 to be paid in full by what date did we give him? February? I'm not gonna give him that long. Within 30 days, he must have the 300 paid in full. That means it must be paid by December 13th, 2024, or I will find him in further contempt. And then I want to address his failure to follow my instructions to appear at the courthouse later that day. I will hold off on that issue until I see how he behaves from this day forward on this case and whether he pays as ordered. And this is the last one. He's going to be doing more contempt jail time if he doesn't get that paid as ordered in 30 days.
Understood.
Okay. So apparently he will stay out on his $1,000 OR bond that he convinced Judge Ricky to issue if he had that paid within a week. And he didn't. Anything else, counsel, that we need to address?
Not for purposes of today's hearing, Your Honor.
No, Your Honor, thank you.
All right. Mr. Phillips, are you still employed by that same company?
Yes, Your Honor, it's Nowak Construction.
Yeah, why don't you tell me that since you wouldn't before? Nowak, Nowak?
Yes, ma'am, the same people that are doing your guys' water system here.
Okay, and that's in
Goddard, Kansas,
Goddard? All right. And where are you living now?
1127 North.
Oh, stop. You're on YouTube. Is it the same address you put on that OR bond?
I
That Judge
believe
Ricky had you sign?
I think I have a copy, Your Honor, for giving me a second.
Yeah, it is. It's the same one.
Yes. You
Okay.
don't want to.
Now, Trooper Lieber, I did not ask you, and you've sat here all this time since 1:30 or before. Are you available for jury trial if it goes in February? Because if I need to set it for jury trial, it will be February 4th and 5th. We haven't gotten there, but if I need to, are you available?
Yes, ma'am, we'll make it work.
All right. Well, thank you for your patience and dedication to this case, for being here. I'm going to let you go at this time unless Mr. Regier needs you for anything else.
Not to my knowledge, Judge. I believe this is the last case on this afternoon's docket.
All right. And do you have anything else on this matter, Mr. Regier?
Not to my knowledge, Judge. I believe the court has already addressed the prior goings on in this case far better than I can.
All right. Mr. Zolator, anything further?
Your Honor, I was just conferring with the deputy. You just said 4th and 5th at the jury trial. We had written down the 5th and 6th. We just want to make
It
sure.
is the 5th and 6th, Trooper Lieber. It is the 5th and 6th. Now, one more question I have. I show that there was to be a cash-only bond of $500, but that he paid the 1,000 OR. So, Jen, can you look at that screen and tell me anything about why that's inconsistent? Is it because the judge changed it, maybe?
Your Honor,
Yes.
you're referring to his OR bond?
Right. So
Judge Ricky set his OR bond, so he didn't have to put up any money. He just had to sign the paper to leave.
okay, he didn't have to put up any money, but he was ordered to pay the 500.
Yes.
within a
Now, if
week.
he fails to
Alright.
appear in the future, the county attorney can go after the $1,000.
Okay, all right. There you have it. So if there's nothing further, Mr. Zolator, you and your client are excused, as is
Thank you.
Trooper Lieber.
Thank you, Your Honor.
Thank you all. And this docket is adjourned for today. Did you
Is
have?
the clerk's office still open?
Yes,
Okay,
till 5.
all right.
Okay,
They're gonna make the payment.